Well, everyone, it's my pleasure tonight to introduce Matt Fisher. Matt is based in London at the UCL Faculty of Laws. He's been there since 2009 after moving to that faculty from Bristol. Matt knows the best part of intellectual property is definitely patents. We're glad to have a comrade. And has a special interest in patent claim construction and Swiss claim patents, which is very ably assisted by having not only a PhD in law, but also a background in chemistry. Tonight, he is going to be taking the piss out of patent law. I mean, the Pith. Oh, we hope so. At least defending the Supreme Court's introduction of doctrine of equivalence.
Modest defence.
Okay.
It's probably as far as I can go, but thank you very much for that introduction. Thank you for inviting me as well. This is an area which, if I'm honest, is something that I've probably been thinking about for the last 20 years, which makes a lot of what I've got to say interesting for me, because there are some new bits that are coming out as I think about this more. But it's also something which, for a long period of time, I didn't ever think that the things that I advocated originally in my PhD thesis would get noticed, let alone accepted, let alone sort of see them being applied by the Supreme Court. And so I'm now in a slightly bizarre situation where some of the things I'm advocating, or I advocated in my thesis thinking that they were pipe dreams, I'm now trying to defend. Mm-hmm. And that causes some difficulty. But if we think about patents and equivalence, then one of the things that obviously those of you that are in this room are aware of are that we've got two distinct functions of the patent claim within the European Patent Convention. So first and foremost, you've got the definition of the matter which is sought. And then we've got the extent of protection being determined by the claims. Now, if we think about those two aspects, then in the Patents Act 1977, these are combined within one provision. That we get in section 125 the idea that the patent claims define the matter or define the invention and determine the scope of protection. But in the European Patent Convention, they're separate. And that, to me, is something which has been overlooked by the individuals that have been dealing with this for a number of years. Because there is a very definite distinction between claims being used to define something and claims being used to determine the scope of protection. Now, we were told for many years that under the old approach, one question could be used to deal with the claims, that we were looking at the claims linguistically, that we were looking at them and simply saying that the language of the claim tells us what the scope should be, and that there is this impermeable membrane across which we cannot, or through which we cannot cross, once we get to the stage of having interpreted the language, finding out what the patentee intended, finding out what the patentee meant by the language that they chose. So for a number of years, we used the claims as walls that defined the scope of the invention that we couldn't end up moving beyond. Now, part of that was based on the idea that the extent of protection shall be determined by the claims. And certainly, Lord Hoffmann, when he was speaking at the Fordham conference a few years ago, was very clear that when he was telling us how the claims should be interpreted in the Amgen decision, that what he was trying to do was stay within the language, that there was no intention on his part whatsoever to go outside of the linguistic bounds that the patentee had themselves expressed within their claims. And he said that, looking at Article 69 EPC, nothing could be clearer than the statement there that the extent of protection shall be determined by the claims. Now, for a number of years, I thought that that was a bit dodgy. And part of the reason for that is not only the clarificatory statement, the so-called Goldilocks provision on the protocol and the interpretation of Article 69, that the claim should be interpreted not too literally, not too liberally, but just right in the middle. And that due account should be taken of any element which is equivalent to an element specified in the claims. Now, in terms of taking due account of an equivalent, and I'll deal with equivalence in more detail in just a while, the approach that seemed to have been taken to equivalency under the old Amgen decision was that if you thought about equivalence, you had them in your background of your imagination, that allowed you to come to a reasoned consideration of the language of the claim, so that you could take those things into account when you decided what the linguistic bounds of that claim meant. Now, by that same sort of logic, when I look at my emails and I decide not to answer some of them, then I'm taking due account of my emails. I can consider it, I can exclude it, and that's perfectly okay, as long as I've thought about it. That may not be something where, realistically, we are taking due account in the way that it was intended in the protocol. And again, I'll come back to that in just a while. One of the things that's worthwhile noting is that one of the criticisms of the current approach is that it is now something which deviates us from a degree of certainty, that we are in a system where uncertainty reigns, where we've left the words behind and now we are looking simply at some unknown grounds that we've trespassed within. But once we go beyond the language that the patentee sets themselves, once we accept that equivalence may fall within the scope of protection, then we cut away our mooring and we drift off into the future. And I thought it was just worthwhile noting this quote. Modern techniques of interpretation are so flexible as to make any but the simplest question of infringement depend heavily on the court's impression of the general merits of the parties to the dispute. This is another way of saying that the findings of infringement depend largely on matters of prejudice. And the reason that I raise this is that this was something that Blanco White said in his 5th edition of his textbook in 1983, just after the Cabinet decision. So at that point in time, when purposive construction was just created, when the language of the claims was something which was now a single-stage assessment of scope, where the old Pith and Marrow approach, the 2-stage assessment of infringement, had just been cut away. And Blanco White thought that that was something which, once again, made any question of infringement depend heavily on the court's impression of general merits, rather than on any question of language. Equally, if we look at something else that was written in 1983, purposive construction, the interpretation of claims made in many cases, is anything but certain. The considerable flexibility possible in construction results in uncertainty. So this myth of certainty, this myth that when we have a single stage construction, that is inherently more certain than a dual stage, is something which was questioned at the very time that the single stage of construction was put in place. It was something which scholars at the time were hedging their bets in relation to. Now, part of the reason for that, obviously, is that any change results in uncertainty. That people are used to the old approach and therefore they know how to deal with it. And so, obviously, changing that to a new way of thinking about things will introduce a level of uncertainty. The question is whether that level of uncertainty is intolerable, whether that level of uncertainty goes beyond something which allows us to think of the claims as relatively predictable in terms of their scope of protection. So, in relation to the question of equivalence, if we have a claim to a sodium salt of a compound, does this cover other salt forms? That is the question that was being dealt with essentially under the Actavis decision. Where we had a claim to a sodium salt, does the difference in sodium or potassium cation, which plays no part in the eventual reaction or in the eventual treatment, it dissociates the sodium cation, the potassium cation floats around, and it's the other part the equivalent of the chlorine, the pemetrexid in that particular case, that actually had the pharmaceutical effect. So does it make any difference what we stick to it? Now, from a practical point of view, it didn't make any difference. The fact that we've got potassium or sodium was still perfectly effective, whether or not you've got this redundant particle that's stuck to it. Now, there may be some issues in relation to a potassium salt as opposed to a sodium salt. Potassium, for example, is a lot more soluble, usually, as a salt than sodium. So there may have been issues with solubility. There may have been other issues in relation to intolerance, in relation to potassium, and the fact that increased levels of potassium can cause problems. But for a practical purpose, it made no difference. This was an entirely, you go back to the old way of thinking about things, this was entirely something that was immaterial to the way the invention worked. The core of the invention in the Actavis case was about the pemetrexid, the combination with vitamin B12. That was the core and the key part of the reaction. So packaging it up, obviously, from a linguistic perspective, sodium does not equal potassium. Now that's straightforward. So we would think from a linguistic point of view only, that if you specified one thing, then you disclaimed the other thing. That is what we've been schooled to understand from the early days of patent law in this country. But what is not claimed is disclaimed, that anything that is specified in the claim is a limitation that we have to take consideration of, and the deviation from that is problematic. So the Amgen approach, as I've said, was something which was a single question. What the skilled addressee would understand the patentee to have used the words of the claim to mean. There were then a series of extra elements that landed into this. The patents were based on skilled advice. So the possibility of deviating from the usual word, or the usual meaning of a word, was small. Conventions of grammar and language mean that we can use words in a particularly pointed way. We can use words with a degree of precision. We are able to specify with a high degree of precision what exactly it is that we mean. And so we need reasons to depart from convention. We need some kind of reason to depart from that gut reaction of the word that we get. Now, there was no doctrine of equivalence, but they get taken into consideration as part of the background knowledge of the skilled addressee. So from Lord Hoffmann's perspective, by taking this into consideration as part of the background knowledge, effectively you're priming yourself with the idea that this person could have used particular bits of language in a slightly unconventional way. There is, however, a problem with this, which I'll come to in just a while. We're still not allowed to go outside of the language. We're still not allowed to deviate too far. But where there is a degree of flexibility, then equivalence could be taken into consideration. He went on to say that the doctrine of equivalence was born of despair. Despair created by the shackles of literalism. And if literalism stands in the way of construing patent claims so as to give fair protection, there are two things you can do. One is to adhere to literalism, and the other is to abandon literalism. And so what the English courts, he thought, had done was to abandon literalism. And that's fine, if we agree with that. And one of the reasons why I don't agree with that is that literalism in that sense, literalism in the sense of the ordinary meaning of the word, is something that is inherently attractive. It's something that has an almost aphrodisiac quality to it. That we as speakers of the English language like to assume that we use words, and when we use words, we know what they mean. But we don't use words in the sense of Mrs. Mallock, so we use the incorrect word in a particular context. We also like to assume that when we've chosen a word, and when we approach a word, that we're able to see different types of meanings and take those into consideration. Now, scope is determined by the claims is a good example of this approach. Because when Lord Hoffmann approaches the question of scope being determined by the claims, he sees determined as meaning that scope is determined in the sense that it is fenced in, that there is a castle, that we've got protection inside the castle, and that the walls of the claims provide a defensive system around the outside. So determined is something that he takes a very clear view on. Determined, he says, is something that means we can't go outside of the claims. Determined could not be clearer. That scope is determined by the claims must mean that you're not allowed to go outside of them. I ask you just for a second to look at this map. This is a map of territorial waters, the territorial sea, which is dealt with under the UN Convention in relation to this. And you can see that the extent of the territorial sea here is at the little purple outline that sits outside of the coastline of the United Kingdom. Now, the extent of territorial sea is determined by where the coast is. There's nothing inherent in the word determined that means that we can't go outside of that boundary. As long as we know what the boundary is that we're going outside of, as long as there is a measure. And that's a critical thing. If there is a measure, if we've got a hand on the coastline, we've got a hand on the extent of the territorial waters, then we know that it's determined. If we don't know how far outside of the coast, how far out of the low water mark the territorial water extends, then obviously it's not determined. But there's nothing inherent in the word determined that says you can't go outside of whatever it is that you're using to determine the extent of protection by. So that's one reason why I think ignoring equivalence earlier on is problematic. There's also a historical element that I've written extensively about, and I don't want to go into necessarily here, but once we realise that we're not bound by the language of the claims, in the sense that the English courts thought that we were, then how do we go beyond that? And why is that not necessarily any less problematic than it would have been under purposive construction? And in order to understand this, we need to go back a bit and think about the broad concept of purposive construction that Lord Hoffmann himself outlined. Lord Hoffmann outlined what he understood by purposive construction in a speech to German patent attorneys in 2006. And he said that the idea really was that legal interpretation shouldn't be any different to the way in which we approach linguistic interpretation in normal conversation. And so he gave the idea, gave the little tableau of a domestic interchange that had apparently occurred in the Hoffmann household sometime earlier in the week. He was about to do some washing up, and Lady Hoffmann, seeing her husband besuited, dish mop in hand, advancing upon the kitchen sink with intent, had asked him, "Why don't you put on your umbrella?" Now, despite, or perhaps because of the fact that umbrella makes no sense in that sentence, then he opened a cupboard, took out an apron, put it over his suit, and tied it up. And this, he remarked, seemed to satisfy his wife. So notwithstanding, therefore, the conventional definition of umbrella being able to embrace or cover an apron, the context of the interchange, he said, led his lordship to divine his wife's intended meaning. Now, this example is used by Lord Hoffmann to illustrate the inherent flexibility of language within the realm of communication. It's one of a number of domestic tableaus that he used over the years to perform the same function. So in some of the contract cases, he ended up talking about Mrs. Malaprop, and the idea that Mrs. Malaprop, character in Sheridan's The Rivals, when she says that she's as obstinate as an allegory on the banks of the Nile, we look at that, we identify the fact that allegory makes no sense within that sentence, and so we substitute another word for it. And this apparently is part of purposive construction. Now, if that's the case, then we've got problems, because that's not construction. That's not interpretation of the language. That might be interpretation of the communication, of the overall packet of communication. But that is not interpretation of the language used. There is no way that we would look and say, apron means umbrella, umbrella means apron, in that sort of scenario. There's no way that what we end up talking about, there's no way that that is an interpretive endeavour. Now, on the assumption that words and grammar are being used in a normal manner, then we can't say that an umbrella is an apron. As soon as we remove the word umbrella from that equation, then the point becomes even clearer. If Lord Hoffmann's wife had said, why don't you put on your, and then just stopped. And then he'd gone on and taken the the apron out of the cupboard, then once again, you can't interpret nothing as something. So from the context, you're looking at the first part of it, and then it's conjecture as to what will fulfill that. Now, if that is purposive construction, then really we're in a situation where error correction is being utilised. Now, the space for that to occur within the context of a patent is obviously next to nil. But it's one thing, perhaps, to say that we extract meaning from such an interaction. And it's another, I would say, to say that this is interpretation at the level of the sentence itself. We may imply that when Lord Hoffmann, or Lady Hoffmann rather, asked his lordship to don the umbrella, she was really meaning to refer to the apron. But this, as I've said, is a level of conjecture, this is implicature, this is not interpretation. This is something where we're using our experience of the world to correct an error, to heal something within a document. Now, that's one reason why the broad concept of purposive construction is perhaps problematic. But we also have a problem in that words are tricky things and they're not of invariant meaning. And you might say, well, we could look to a dictionary and we could see from the dictionary definition that a word means something. The trouble is, once again, that if we've got a dictionary definition of something, then that's one person's suggestion of some kind of substitution of different words for the word that is being defined. And that comes pre-charged with an element of subjectivity. Different dictionaries will have different definitions. Some dictionaries will have better definitions than others. And some dictionaries will have very bad definitions altogether. A classic example of this is Chambers' 20th century dictionary of the English language. A perfectly credible dictionary, a perfectly reasonable dictionary. It defines a donkey in that dictionary as the ass. Fine, providing we know what the ass is. So we then follow this definition. Now, the ass is a well-known quadruped of the horse family. A well-known quadruped, not the well-known quadruped, but just one of many. A horse, however, is also a well-known quadruped, and the rest of the definition adds nothing to that. So a donkey is a well-known quadruped of a family of well-known quadrupeds. And unless you actually know what any of these things are, these definitions are practically meaningless. For those of you that are interested, a goat is also a well-known quadruped, this time allied to sheep. So when we're thinking about dictionaries as a source of definitional clarity, we may find a degree of clarity, but we may equally not. It depends where we're looking, and it depends what we're choosing. And when it comes down to choices between words and equivalents to those words, then it also depends on what the dictionary is that we start off with. And so what we see in a number of decisions, in particular in the United States, where dictionaries are put forward, is that one dictionary is pitched against another dictionary definition because one is clearer, is the correct interpretation, and the other one is an incorrect interpretation, but obviously the other side thinks it's the other way around. So a dictionary is not necessarily a great place to start. So what do we do when we interpret things? The other problem is the patentee is not a clairvoyant, they don't possess a crystal ball, and so there's also a duality of purpose. And if we think about duality of purpose, we're not only concerned with the meaning of the words themselves, concerned with what they do, their legal effect. And Fletcher Morton, back in the early part of the 20th century, said that we can't forget that the question of construction is only one part of what we're looking at. Questions of infringement is always closely joined with that of construction. It's only natural, since once it's been established that what the defendant has done, it would appear to be only a question of construction, whether or not it's within the monopoly claimed. However, it has to be remembered that whilst the construction of the specification was always a question for the court, a further question of substantial identity of what the defendant has done with the invention for which the monopoly was granted was for the jury. So there's a question of fact. What does the language mean? And then, does this thing fall within that language or that scope of protection? Now, that was something which, again, Blanco White, in his 1983 treatise, reminded us that even after the Catnicked case, there were still two questions that effectively needed to be asked. What did the claim mean? And that was addressed through the eyes of the person skilled in the art. And then what effect did that claim have? And that was something which I think got lost in subsequent years. That the factual exercise of mapping whatever was done onto the claim language was something where the courts looked for an absolute overlap, rather than appreciating that there may be some degree of flexibility. It's a question for the jury, a question of fact. Have you taken the essence of the invention? And by determining, or using the language of the claims to determine the scope of protection in a very narrow sense, we walk away from that. But one of the reasons why I think there is a particular problem with any approach that doesn't explicitly deal with equivalence as a separate element and a separate discussion is due to some of the stuff that's been written on cognitive psychology. So cognitive bias, heuristics, the issue of linguistic interpretations. If you look at Daniel Kahneman's work, and in particular his 2011 bestseller, Thinking Fast and Slow, then he talks about the ways in which we approach decision-making. And he says that thought processes can generally be arranged into two broad categories. And this is what Keith Stanovich and Richard West had originally termed System 1 and System 2. Now, System 1 is the automatic one. It is the largely unconscious, the gut reaction that we get to something. It's relatively undemanding. It's effortless. It takes no concerted effort to come to a conclusion. It just arrives in our head. It's the sort of thing that we get the first time we see something. It's fast. It's governed by habit, and it's relatively inflexible. We automatically come to these conclusions. And it's also parallel. So he talks about this being cognitively easy. It places little burden upon the individual. These ideas, these thoughts are the first responders in our mental arsenal. It's our gut reaction. They're impressionistic, they're intuitive. And they automatically occur, they take little or no effort, and they don't disrupt each other. They can occur in parallel. So when we're thinking about, for example, words in a sentence, we don't sit there and pass the sentence up into its individual word units, holding all of these elements separately in our heads. So we don't simultaneously hold, for example, pictures of river walls and financial institutions in our heads when we look at a sentence that contains the word bank. We determine from the rest of the context exactly which one of those two we're talking about. And so the immediate context of the sentence is something that we take into consideration very quickly as part of System 1 that gives us a clear idea about how the words in that sentence should be interpreted. System 2, on the other hand, is slow. It's something that is more measured, effortful. It is a serial processing standard. It's more flexible than its impetuous sibling. It's rule-governed, and it's something that corrects, endorses, or overrides the initial gut reaction that we get from System 1. However, there is a problem in that generally, humans are cognitive misers. And what this means is that we possess limited mental resources. We're reliant upon sometimes irrelevant cues, and we struggle with correcting the initial thoughts that we come to under System 1. So what this means is that we take shortcuts and that the monitoring by System 2 is rather light touch. And the shortcuts that we take are so-called heuristics. Now, there are a whole host of these that have been dealt with quite considerably within the literature. But typical System 1 shortcuts include what's known as prototyping. So the idea that when we see a word, we think about what the prototype of that word is. So if you think about birds, for example, studies have shown that the prototype bird is basically a robin, that a penguin is not a very good prototype bird. However, that doesn't mean that a penguin is not a bird. But nevertheless, when we think about birds, we go immediately to the prototype. And if we do that when we think about things that are claimed, then we're likely also to jump to whatever the prototype of the thing is that is being described. And that is something that then latches with us, and it's difficult to shift. There's also what's known as attribute substitution. And when faced with a difficult question, people often unthinkingly substitute an easier one instead, something that more readily comes to mind. They then proceed to answer that as a proxy for the original. And we see an example of that again if we think about the approach taken to a patent's claims. We're meant to look at it through the eyes of the hypothetical skilled addressee, a person having ordinary skill in the art. This is a person who has a number of attributes. They could be a member of a team. They are someone who's well versed in the workshop techniques. They have all the things that the cases tell us that they possess. No skilled addressee has ever or will ever exist. They are a hypothetical construct. They're an artificial construct. In which case, even though we're supposed to be viewing this through the eyes of the skilled addressee, that's quite difficult to do, because we have to imagine ourselves in the head of something that doesn't exist. We have to imagine how that thing would interpret the language that we ourselves already know how we would try and interpret it. So the gut reaction approach to that is to, rather than ask that difficult question, how does the skilled addressee view it, to ask instead, well, what do I understand by this word? And in order to do that, we may well go back to what the prototype is. There's also a problem with light touch monitoring because there are some weighting biases that then get involved. In particular, confirmation bias and false consensus bias. Now, confirmation bias comes from the fact that because these heuristics depend on our worldview, the way in which we understand the language to be determined, then confirmation bias looks for things that support that view. And we're far more likely to bake in an initial view that is reached intuitively, which is not subject to immediate correction. We're apt to seek out, we ultimately believe, information that confirms a personally held hypothesis, more than we are information that discredits it. Now, this is something where if we've ended up coming to a view, forming a view about the meaning of a word, deviating from an impulsive view, making the word signify something else by stretching from a starting definition, staying within the confines of that word, trying to massage the meaning of the word itself, feels like an intellectually dishonest process. Because you look at it and you say, well, that's what it says. So how can it therefore mean something else? How can it mean what the defendant tells me it means? There's also false consensus bias, which again bakes this in. Now, false consensus bias is illustrated quite nicely by this discussion that was made by Solon, Rosenblatt, and Osherson, which was to do with contract interpretation. It is one study, but nevertheless. Questions of interpretation in some contract cases were put to 64 judges in 2 scenarios. And they were asked to decide whether this conformed with outcome A, outcome B, or whether they were undecided. And these are the results when they were asked for their opinion. So these 64 judges, 12% of them thought in scenario 1 that concerned something to do with Earth movement, that outcome A, that this was something that was caused by Earth movement, however that was defined. 61% thought it wasn't, 27% were undecided. In scenario B, which was to do with pollution, then 23% thought that it was pollution, 71 thought it wasn't, 7% undecided. That is not the interesting bit. This is the interesting bit. They were asked how many of their peers would come to the same conclusion as they did. What proportion of 100 of their peers would come to the same conclusion that they did? So even those that were undecided were overwhelmingly confident that 8 out of 10 of their peers would also be undecided, when in fact they were in sub 10th percentile, or sub 10% here. So what this tends to illustrate is that when we come to a conclusion, we believe that other people will also come to the same conclusion. We believe that in these sort of circumstances, we are the majority. Now that is something which again causes some issues for me when we get to the stage of looking at claim construction. Because from the perspective of looking at a claim, we all assume that our view of that claim is the normal view of that claim, if we accept the heuristics, if we accept the prototyping, etc. We also have false consensus bias, so we think that everybody else will agree with us. If that's the case and everybody else does not agree with us, then the degree of predictability that we have when we look at something, or when we come to a conclusion, is not necessarily shared by other people. So we're necessarily in a system where the heuristics point towards a degree of unpredictability that we think is perfectly predictable. So if we've only got one question to ask, what does this mean? And we take a shortcut, then we end up in a situation where we've got some problems trying to actually justify that being a wide view of the issue. And a good example of that can be found if we think about the Catnick case itself. It was only after the Catnick case, so Catnick with the steel lintels. The steel lintel claimed with a backplate extending vertically from the floor plate. Up until the House of Lords, 84 degrees incline on a backplate was not vertical. It was only at the point that the House of Lords defined vertically in that way, as including 84 degrees to the horizontal, that suddenly that becomes the definition that we have. So until that point, everybody thought that a backplate extending vertically, the Court of Appeal thought a backplate extending vertically meant geometrically vertical. The Court of First Instance thought a backplate extending vertically meant something that was at 90 degrees to the horizontal. So it's only at the point that we've got this final determination on the issue that it changes. Now, if that's the case, then we're in a very odd position. Because conceivably, there could have been a bit of prior art that was out there that suggested that 86 degrees was already in the prior art. And so vertically was something designed to extend outside of that, to miss that particular cut-off. So we already had a situation under Catnick where the meaning of the words changed over the period from first instance from the Court of Appeal, from the Court of Appeal to the House of Lords. If that's the case, then we end up in a problematic situation once again for certainty purposes. How can we have something that is certain if the only point that we find out that it is certain is at the point that the House of Lords gives its final determination on the matter? Is that a relevant degree of certainty? Now, it might be something that is inescapable, but it's still something I think that calls into question this one stage, this single stage approach, and the idea that that is inherently certain. Now, the benefit of all of this, and I have more stuff in relation to Improver and Remington, which I could talk about a bit if you want. I have more stuff in relation to Occitec and the way in which biases work. But people don't believe that they're biased. Cognitive psychology suggests that people don't believe when they're told that they're biased. The benefit, I would say, of establishing a defined equivalence analysis is that we have to engage System 2. Because System 1 has told us what the language meant. We're then asking an entirely separate question. Shall we deviate from that language in predictable ways? And so that is something which has to be a deliberately controlled question. It has to be a consciously monitored question. It has to be something which is effortful, slow, and it has to be something that is performed separately. Whether the Supreme Court actually managed to create a system where it was predictable in terms of their approach is a very big question. One of the problems that we have is that the test that is utilised by the Supreme Court is full of holes. For a start, this is something that applies to all patents, whether they've been drafted with this in mind or not. That's a big problem. Because if you're drafting a patent based on the idea that the words are walls, that you can't go outside them, there's no clear reason why you should then get the windfall of equivalents going outside of that. If you've drafted them with one particular end in mind, then getting something else looks problematic. There's also inherently within this second question, hindsight that is baked in. Would it be obvious to the skilled addressee reading the patent at the priority date, but knowing that the variant achieved substantially the same result? Hindsight bias is another problem. The more people think about why things could have turned out otherwise, the more they may convince themselves that the outcome is in fact inevitable. And with this question, the second question, knowing the variant achieved substantially the same result, the homunculus that's sitting there on your shoulder is probably saying, well, if we know, and it would have been obvious, that this achieves the same results, then surely it's something which should be within the scope of the patent. Now, if you're thinking about it the other way around, and that this is just the approach to purposive construction, which is another problem with this particular instance, repurposing the test for the first stage of infringement for the second stage of infringement is wholly problematic. But if you're thinking about that from that perspective, that the words are absolute walls, then you go through this under the old improver approach and say, does it work in the same way? Yes, it does. Was this obvious that it works in the same way? Yes, it was. In which case, why didn't you claim it? Why wasn't it explicitly within the language of the claims? So if you know that the claims have strict boundaries, you apply these questions. You say, well, obviously, you conclude that strict compliance with the literal meaning is an essential requirement. You never get out of that language. You never deviate from it. Put in this context, however, does it achieve substantially the same result in the same way? And then would it be obvious that it achieves the same result in the same way? Knowing now that you can step outside of the claims, inevitably you say, well, yes, that must be something which is within the scope of protection. So would the skilled reader nevertheless conclude strict compliance was an essential requirement? Probably not. There's a twist in the way in which we balance that is, I think, problematic. And it comes from using exactly the same questions for one purpose and another. There's also a lack of restraint here. Prosecution history is stopping. So the fact that you could have said something different in prosecution is effectively ignored by the courts. That can't be right. Because saying that you're giving up some scope and then collecting it later by the doctrine of equivalence must be a bad thing. In addition to that, there is no restraint in relation to the state of the art. It is perfectly plausible here, perfectly reasonable, perfectly acceptable, apparently, to institute a claim that you say is narrow at the stage that you're assessing validity, and you then expand it with the doctrine of equivalence, and it catches something that is in fact old. At the moment, we have no way of dealing with that. There's no defense of state of the art. And that must again be utter madness. So I think it was irresponsible of the Supreme Court to go forward and to suggest this as a test without thinking about those further repercussions. They didn't think about the validity issue, they didn't think about they did think about prosecution history and stuff, and they ignored it. I mean, it would make claim construction a lot more complicated to have those elements in. But there are certain safeguards that need to be put on the claim to contain it in certain ways. I've gone way over my time.
No, usually rental bed, so.
No, I haven't gone way over my time. In which case, I'll start questions. I'll stop there.